Welcome everyone to our last in-person Tuesday Times Roundtable on the topic Death Penalty Defense, the role of mitigation in state and federal cases. This is a very important topic and we encourage you to approach it with an open mind as we dive into the discussion. My name is Janeri Mendoza Farjan and I'm the Senior Program Coordinator here at the Office of Global Learning Initiatives. TTR is our Office of Global Learning Initiatives flagship discussion series that brings together multiple perspectives on current global issues and trends while fostering meaningful conversations on topics aligned to the United Nations Sustainable Development Goals. As a reminder to all students, please take a moment to sign in by using the QR code, whether you're here for Global Learning Medallion points, Honors College engagement points, extra credit from your professor, whatever brought you to us, we're glad that you're here. If you would like to learn more about the opportunities at the Office of Global Learning, including the Global Learning Medallion, Peace Corps Prep Program, fellowships, and scholarships, make sure to follow us in Instagram by using the QR code or visit us at the front entrance. Also, join the FIU College of Law on Tuesday, April 8, on a discussion on Florida's modern death penalty. You can sign up by scanning this QR code, and this is a sponsored event by the Balance Justice Project, a legal aid instrument within FIU's Law Clinic, which operates as a nonprofit through the FIU Foundation. And TTR is also centered through global issues and trends, and we always linked it to a news article. So today's article, you may access it at go.fiu.edu/TTR0325. And this is due to our formal partnership with the New York Times that provides digital access to everyone with an FIU email. So you can activate your account at accessnyt.com.
Today's Tuesday Times Roundtable is connected to SDGs number 16, Peace, Justice, and Strong Institutions. And this is to provide access to justice for all and build effective, accountable, and inclusive institutions at all levels. To learn about the target indicators and the progress on this goal, visit go.fiu.edu/SDG. All right, and now to introduce today's presenters, please join me in welcoming the leader behind global learning at FIU and the founding director of our office, Assistant Vice President of Global Learning Initiatives, Dr. Hilary Landorf.
I have the pleasure of introducing our panel speakers today. First, Susy Johnson. First and foremost, she has the meanest forehand in Miami in tennis. Secondly, she's a distinguished attorney with an extensive background in capital defense, civil rights, and advocacy for prisoners' rights. Her passion for capital defense began at the West Palm Beach Public Defender's Office, where she co-counseled the penalty phase retrial of a case securing a life verdict for a client after 23 years on death row. She then joined the Capital Defender's Office in New York, where she worked on over 100 death-eligible cases, tried 2 capital cases, and mentored private attorneys in death penalty litigation. She later worked as a capital defender until New York abolished the death penalty in 2005, having tried 5 death penalty cases and worked over 500. Susy is trained in defense-initiated victim outreach, and we can ask her about that, a practice that began with the Timothy McVeigh trial, which allows victims to engage with the defense team. She is a graduate of the University of Florida's College of Law and studied for a year at Oxford University. And to her left is Samantha Lopez, Susy's great niece and cohort and partner in not crime. Samantha has been investigating the life histories of those facing the most severe criminal penalties possible in the United States. She founded Untold Investigations, a private investigative agency dedicated to conducting high-quality life history investigations in state and federal criminal cases. She primarily focuses on capital criminal cases, but also works on state and federal non-capital and juvenile sentencing cases. Samantha says that she's a second-generation mitigation specialist, having learned the profession from her great aunt, attorney and mitigation specialist Susy. But I know that Susy also learns a lot from Samantha, and we're going to see that in action right now. So it's my pleasure to introduce you both.
Thank you. Okay, first let's look at the... now that everybody's here and comfortable, I'm going to ask that everybody just kind of get out of their comfort zone and bear with me. And if everybody can just stand up for a few minutes. So I'm going to ask you guys a following series of questions. This is no judgment zone. You know, your opinions, your views on the death penalty are your own, and you're entitled to them. Everyone that is opposed to the death penalty in all cases, regardless of the circumstances of the murder, please sit down. Everyone that thinks that the death penalty is the only appropriate punishment when a person has been convicted of first-degree murder, please sit down. Awesome. Those of you that are left that find that the death penalty is generally appropriate with very few exceptions, please sit down. That leaves me with those of you that believe that the death penalty is appropriate in some cases and not appropriate in others, and those who are generally opposed to the death penalty with very few exceptions. So with that being said, the people that are left standing, who do I want to pick? I'll start on this side. Let's start with you.
Juror number 1.
If a defendant is convicted of first-degree murder and the two punishments are either life in prison without the possibility of parole and the death penalty, and the defense team was tasked with the job of mitigating the client's life, presenting factors related to the client and their lives that would impact your decision, what kind of factors would impact your decision on whether or not to vote death?
Let's say this. Let's say that this is a MS-13 case, which there's a lot of them. That's a gang. MS-13 is La Mara Salvatrucha. Let's say that the person has been found guilty already of killing 4 people, first-degree murder. In that case, Samantha's question is, what would you like to hear to mitigate against the death penalty for you to consider giving a life sentence?
I would want to know what their lifestyle is, like past what they've done, like what they do as a profession, if they have kids, if they're married, what state they're from, if they're a U.S. citizen, if they have a college education, a high school diploma, things of that nature, just to see what life they lived like prior to the crime that they committed.
Okay, thank you. You can stay standing. Next person, we'll pick from this side, the gentleman in the second row.
Is it the same question?
Yeah, same question. So if the client had already been convicted of first-degree murder, is there anything that we would be able to present to you that would sway you towards life or death?
I think generally speaking, a life sentence would be a more appropriate conviction, because I believe that the death sentence is more suited for enemy combatants and terrorists over killers and shooters, because I believe that the life sentence is a worse punishment in a sense, because life in prison can be very tough, especially when you have solitary confinement, you have prisoners that commit crimes against each other. So it's not necessarily an easier, I feel like a death sentence is the easier way out, but for enemy combatants that can still kind of be affiliated with our enemies, it's better to just give them the death sentence.
Awesome. Thank you. We'll come back over here. You with the star on your shirt. Same question.
Well, I would like to know if he regrets like the committed crimes that he did, and if he wants to change his life or something like that, and that would be it.
Those are the only two options that you would consider.
So, like,
If there's remorse, you're saying if there's remorse. Okay.
I'm going to ask you to have a seat.
And we're going to have one more question,
Yeah.
because otherwise we can't get through
Yeah,
our presentation.
over here.
purple.
Volunteer.
Same question.
Yes.
Thinking of the factors, sorry, I have a bit of sorry, that I will also look into the mental history of the client, because in my case, I have autism and other things. So I also look into that, because people with disabilities can also, they may not look facially or look the same as people or experience the same emotions as other people. So it's the same way. So I feel that that will also be a mitigating factor for me. Besides the other factors, is that factor, the mental, capacity.
Very good.
Thank you. So those of you that are still left standing would be sitting in a jury room and qualify for a capital jury. Deaf juries are held to different regards. There's, different qualifications for people who are going to be deciding between sentencing someone to life in prison or the death penalty. As you can see, there's not very many people left standing, which makes it harder to qualify a jury. And we're just asking that you guys keep an open mind in considering a client's life history and in this presentation.
I have a question. Would they know, the details of the killing, like how, and the victims' ages, if they were children?
So at this time, so if you're being qualified for a jury, all you're going to know is what the client is charged with. You're not going to have any details about the case aside from the charges themselves, and you won't know the details until the trial starts with the first part of the case. So you'd kind of have to go into this blind based on just the charges that the state's bringing against the client.
I want to add to what Sam is saying. First of all, because she's so much better than me and a genius, she printed out a jury questionnaire. If you were going to be in a capital case, a case where death is a possibility, each juror, each person that walks into that room has to fill out a questionnaire. From this questionnaire, we're going to have some of you come in. Some of you immediately, like the people that say, I can never give death, I can never give life, those are excluded from the jury pool immediately, because there's nothing that I can do to convince you to give life, and there's nothing the prosecutor can convince you to give death. But out of the veneer, out of the jury veneer, you're going to see in a trial. So we didn't tell, and you can sit down, by the way, everybody else. I'm sorry. Thank you so much. So what we didn't tell you is that capital jurors are, I'm going to say 20 times, 30 times, 40 times more likely to convict a defendant, a person, a client, than a non-capital jury. So in other words, if you have a case, you guys are probably too young for OJ, but OJ was not tried as a capital case. He did not face a death penalty. That jury was not a death qualified jury. Juries that are death qualified, they have to be able to give the death penalty. Otherwise, they cannot sit in the jury. And if you're likely to give the death penalty, you're more likely to think that the person is guilty. And like Alpha Omega, Chi Omega said, like she said, she wants to know the immigration status. That's very interesting because, you know, there is a new law now about that. I'm going to let Samantha speak on that. But really, it's the same person standing in front of you, whether I am from Cuba, as I am, or whether I'm an American citizen. The crimes are the same, but just because I'm from Cuba, I will, in this day and age, I will forego the mitigation phase of the trial, which we will talk to you about, and I will immediately get a death sentence. Think about that. Oh, yes.
Sorry, I have so many questions.
I'm going to let Samantha answer.
Is this I heard about that before the session. Is this a federal thing now?
Okay, so
Sam's got slides and everything.
All of your questions after, but just a quick
out of line.
And I'm going to have Hannah answer that question later. So it's a state in the state of Florida. It's a new law in the state of Florida only. It is intended to be an executive order that was issued by President Trump on a federal level, but for right now, it is just in the state of Florida.
I got taken off a case. I'm doing mitigation on a very, very serious case. And I got a message from the attorney, quit all work on this case. Because they're going to first try the case. If the person is found guilty, it is an automatic death sentence. But we will talk about more of that. Samantha wanted you to know what it would be like to sit in a jury veneer and to get asked those questions. Now, this is just a little glimpse of what we do. Sometimes we sit at the jury table. I'm sorry, at the client's table with the attorneys. I don't know if you guys. We'll talk about cases later, but I know a lot of you are here from the School of Social Work. I know a lot of you here want to be attorneys, may want to be. We're all really needed, and the clients really need us. I want to say that. And like Sam said, whatever your thoughts are on the death penalty, that's what we're going to get into now about it and about the work that we do, which, I mean, mitigation is the lessening or the reasons why not death. The young man said mental health. Of course, that's so important. And I'm going to talk about cases where people have been executed that are totally ID. And obviously, we don't say mentally retarded anymore. Now the proper term is ID. And we'll just tell you about anything. I guess we'll tell you about everything we have on the slide, Sam.
Before we get into what mitigation really is, I wasn't sure everybody's knowledge and how much you knew about the death penalty. So I want to get through these slides pretty fast. And it's just kind of like a synopsis of where we are with the death penalty today. And when we're talking about the state death penalty and the federal death penalty, it's two very different things. And I'm going to focus on the state of Florida, although I do state cases in other states across the country. Florida's changes to the death penalty have been the most severe in recent times, and so they require a little bit more insight. So in April of 2023, Governor Ron DeSantis signed a bill into legislation doing away with the unanimous vote in the sentencing phase of a trial. Now, when you've reached the sentencing phase of a trial, it's because the client has already been convicted of the crime that they were accused of. At this point, in order to get a conviction, it requires a unanimous jury, which was the same for sentencing. In order to sentence a client to death, it required a unanimous jury. I'm pretty sure all of us are familiar with the Parkland shooting and Nicholas Cruz and his life sentence. which angered a lot of people, rightfully so. And we are not here to lessen the impact of the crime or to just kind of set aside the impact to the victims of the case. But we're obligated to consider the client's life, the client's character, and what got us to this point. So in April 2023, Governor Ron DeSantis decided that for a judge to sentence a client to death, it no longer needed to be unanimous, which means before, all we needed to do was convince one juror that our client deserved to live, that his life mattered, that it was worth something. Now, we have to convince 5 jurors. Now, it's the majority 8 versus 4. So if we only convince 4 jurors, our client will be sentenced to death.
Parkland, Sam, say about Parkland having 2 jurors voted for life in Parkland. So that's why.
Yes. So the Parkland case was under a unanimous jury, and there were 2 jurors that understood the mitigation, understood the severity of the client's upbringing, the childhood trauma, the mental illness, the neuropsychological aspect, traumatic brain injury, and those 2 jurors were the reason that Nicholas Cruz's life was saved. In October of 23, Governor Ron DeSantis signed another bill into law allowing the death penalty to be sought in cases where a sexual battery was committed against a minor under the age of 12. This is not a murder, it's just a sexual battery. In passing these laws, Governor DeSantis stated that once a defendant in the capital case is found guilty by a unanimous jury, 1 juror should not be able to veto a capital sentence. Representative Bernie Jacques stated that Florida will no longer allow a small handful of activist jurors to derail the full administration of justice when individuals are found guilty beyond a reasonable doubt and meet the qualifications for the death penalty. It's almost like they are implying that as long as you are found guilty of the crime itself, nothing else matters. And at that point, you should just automatically receive a death sentence. And then recently in January 2025, we know that the legislature passed a very unconstitutional immigration bill that included the provision for mandating an automatic death sentence on anyone that was convicted of a capital crime and also what they label an authorized alien, which is what Susy was just talking about. So if you are convicted of a capital crime and you are not a U.S. citizen, you do not get a sentencing phase. You will automatically be sentenced to death. And so that is what's happening in the state of Florida right now. And it's an infringement on our clients' rights, on the Constitution. And it is a decision that was based out of fear and ignorance. And a decision that, you know, it's going to bring up a lot of issues and litigation and well worth the fight. But basically the government is saying that our clients don't matter and that they are the crime that they were accused of. Now we move on to more information on the Florida's death penalty. The current death row population in Florida is said to be 338 based off the Department of Corrections numbers. A lot of those inmates have now been resentenced to life without parole under Hurst v. Florida. And I'm going to touch on a lot of cases that are like the foundation of mitigation work, and Hurst v. Florida is one of them. So the real number of inmates on death row is said to be closer to 284. Florida is, compared to the national trend that shows that death sentences are declining, we can see in Florida that it's the opposite. Florida has applied the death penalty more than any other state that has the death penalty except California. And we are responsible for over half the deaths in the country. In many, many years, going back to 1982, the US Supreme Court has actually ruled Florida's death penalty practices unconstitutional in the cases of Edmond v. Florida, Hitchcock v. Dugar, Hall v. Florida, and Hearst v. Florida. It is estimated that capital punishment and the death penalty, and when I talk about the death penalty, I'm talking about the trials themselves, the amount of time it takes, the appeals, and just the executions cost Florida about $51 million a year.
Hello.
Hi.
So, yeah, I don't know if it's like a question or a comment, but when I think about like the death penalty cases, a lot of the times when it comes to like, I guess, the trial phase or just the investigation phase, with Black and brown people, like we're more likely to be found more guilty. And then when you go and you're basing it off of the crime that this is the person we are and this is the death penalty. So then you have people who are actually innocent. I know everybody in prison say they innocent, but I'm saying in like those type of cases that they're actually innocent and then they're found guilty of the crime, or even let's go back to the immigration law that was just recently passed. Like they're found, guilty and put sentenced to death, and they were actually like innocent. So it's like how, I guess like, what do we do in like cases like that where the person is actually innocent and then you realize that the cops didn't do what they're supposed to do? So like I'm rewatching the trial of OJ on Netflix, and it's like, yeah, OJ could have been guilty, but the cops did literally everything wrong because they were just trying to focus on proving, oh, I know he's guilty, so let me find everything I need to find to make sure that he's guilty.
So for that, I think we have to be invited back for another.
Yeah, no,
we have to be invited back.
We have a slide that's gonna touch on that and 30 minutes to like
But
make our case.
And there have been a lot of innocent people that have been wrongfully executed. That has been proven, and it's a travesty. I mean, they have the Innocence Project and everything else. And Samantha said there's a slide. But this Miller-Graham cases, what Sam is talking about, that so many people on death row have now come back, they used to give life in prison to minors. Like, think about it. Think about you and your brain prior to 18 years old. I mean, they say your brain doesn't even get fully developed till you're 24. They talk about, So there's so much to talk about on this. And, yes. Oof. Sammy may know that case.
Yeah, and she was only 15. People pointing out, it's like they're likely gonna have to have a retrial because the girl, even though the girl, number one, there was evidence she had problems. Like there was evidence of possible schizophrenia going on. So people say it may have been multiple problems. Plus she's also taking drugs, and if you know about kids, it does not mix well with kids' brains.
No, it does not.
So there's a lot of theories what happened, but in this case, I think maybe a long time mental health city, but I don't think prison for a 15-year-old, adult prison, no, that is not the age. You're not an adult woman, there's a lot of things going here.
Correct, and especially kids that were sentenced to life at age 13, 14. Anyway, I'm digressing.
It's actually illegal. Since someone under 14, it's illegal.
It should be. It should be. I would like you on my jury. That's all I have to say. Sam.
And science actually shows that a person's brain doesn't fully develop until 25. So are you really an adult at 21, or is it just legal to drink? So
we have to get through the slides so we can have more questions at the end. We need like extra time.
Yeah. So just to touch on the federal death penalty really fast, prior to President Trump taking office, there was a moratorium on the federal death penalty for decades, which means that there were no executions being performed. We saw that under President Biden's administration, one of his last acts of mercy was to commute the sentences of 37 men from death row to life without parole. And then from July 2020 to July 2021, the federal government, in a 13-month period under the Trump administration, conducted 16 executions on federal death row. No questions asked. They were just sending everybody to be executed. The federal death penalty has been declared unconstitutional under Furman v. Georgia, and the Department of Justice has decided in 2025 that they were going to reinstitute the moratorium on the death penalty on the basis of lethal injection, because they recognize that it may be a cruel and inhumane punishment. And although President Trump is trying to lift that moratorium, he is asking the Attorney General to overrule their decision and to resume executions. Although federal death row is kind of empty right now, this is where he has begun to add about the number of eligible offenses to death row went up to 60 now, which makes it a lot harder for our clients that are facing the federal death penalty.
Sorry, Samantha did a great job with the slides, but since I can't figure that out, I did paper. In 2007, Lisa Montgomery was executed. Pardon me, she went to trial. Let me see. I'm sorry, she went to trial. She was executed in the last Trump administration. She was represented by Fred Duchard, who's never tried a capital case before in his entire life. I have met him. He is someone that shouldn't even defend a misdemeanor DUI, much less a person that's on trial for her life. Lisa was the only woman on a federal death row. I can't tell you the torture that she experienced at the hands of her mother's boyfriends, her stepfathers, her mother herself, witnessing rapes at the age of 4, herself being raped starting at the age of like 8, being sold. It is just the most inhumane treatment of a human being. People are writing about it. If you ever can read about this, it really is worth a read. But anyway, she was executed, even though people in the field, experts, mental health experts, say that there's never been someone with more mental health issues than Lisa. And that's just one, that's just, I don't know. If that's not travesty and tragedy, what is? But I wanted to mention that because she was executed during the first administration.
We can go on and on about all the travesties of our clients. So if you guys know anything about history, history has taught us that death is different, and the way that we treat death penalty cases is different, in that they require more time, more commitment, more investigation. I'm a firm believer that any case, whether it's a capital case or not, can greatly be impacted by mitigation. However, the courts have not fully recognized the need for mitigation in anything less than a capital case. Death is permanent. It's irreversible. As of July 2024, there have been 200 prisoners that have been exonerated from death row. since 1973. Exonerated means their the decision to find them guilty was completely reversed. They didn't even do it. They didn't do it.
I said that you guys are in college, that you know the word.
For every 8 people that are executed, 1 person is exonerated from death row. I know. In Furman v. Georgia, which is a really important death penalty case, the Supreme Court recognized that death is different relative to other punishments, and that death is unusually severe in its pain, in its finality, and its enormity. There's just no humane way to carry out an execution, whether it's by lethal injection, firing squad, nitrogen. It's inhumane. They want to tell you that our clients don't suffer, but what do we know? So now we get to the point of why we're here, which is mitigation. And one of my favorite quotes from Desmond Tutu, a human rights activist, was, there comes a point where we need to stop just pulling people out of the river. We need to go upstream and find out why they're falling in. From a legal perspective, in 1976, the U.S. Supreme Court rejected mandatory sentencing statutes and established individualized sentencing as a constitutional requirement for the capital punishment, which is death. Meaning it wasn't a one-size-fits-all, and they recognized that each person is different, and you couldn't just apply this straight across the board. The court began defining what constitutes mitigation in the broadest of terms as a diverse frailties of humankind, as a source of mercy and empathy. And although the state and the government frowns upon us trying to solicit mercy and empathy from jurors, that's our job because it matters. Mitigation has no boundaries, and that's under the 8th Amendment. It allows life and death decision makers to extend compassion on an individual basis. In Furman v. Georgia, it was the first time that the U.S. Supreme Court had distinguished between capital punishment and any other kind of punishment. It declared all death penalty statutes unconstitutional as a violation of the 8th Amendment against cruel and unusual punishment. The court imposed requirements and regulations on constitutional capital punishment, that a valid death sentence not result from unguided discretion, and that all relevant mitigation evidence be considered to ensure individualized sentencing determination. Again, in Lockett v. Ohio, the court concluded that the 8th and 14th Amendment required the sentencer not to preclude from considering as a mitigating factor any aspects of a defendant's character or record or any circumstances of the offense that the defendant proffers as a basis for a sentence less than death. In Abdul Kabir v. Quarterman, the court offered this distillation. Our cases following Lockett have made it clear that when the jury is not permitted to give meaningful effect or a reasonable moral response to a defendant's mitigating evidence, the sentencing process is fatally flawed. From our perspective, mitigation is something that is intangible, highly variable in the weight that it is assigned to different individuals. Everybody's story is different. There's no rule to measure mitigation. There's no scale that quantifies empathy-evoking evidence. Mitigation requires no nexus to the crime. I've come across many jurors that want to know why. You know, I'm going to sentence him to death if you don't tell me why he did this. Well, I'm not required to tell you why he did this. I just am required to show you how we got from point A to point Z. And if you can find the correlation between the crime and the client at that point, that's your decision. In capital cases, there are statutory mitigating factors that are outlined in the corresponding state's statutes, and then there are non-statutory mitigating factors.
Sammy, So we're talking a lot of words that you may not know. Like, for example, a statutory mitigating factor. You cannot put someone to death who is under 18 years old. You just can't. That may change, who knows? But right now, they cannot. Like, so but it's very, very sad when your client is 19 and commits a crime. And okay, we have 15 minutes. Imagine all this lies, Sammy. And that's what she means by statutory mitigating factors. What is a non-statutory mitigating factor? What we were talking about with Lisa Montgomery, the years of abuse, of rapes, of violence, of physical violence, of torture. That's non-statutory mitigating.
So homework, right? All of you guys read the ABA guidelines, which were implemented in 1989 and then updated in 2003 to include that mitigating evidence under the ABA guidelines is required as part of an investigation. Any attorneys that forego the mitigation investigation can be found to be ineffective assistance of counsel. The mitigation specialist has long been recognized to be the most important person on a defense team until you get to the trial, which then it becomes the jurors. Wiggins v. Smith was the case that outlines the importance of the ABA guidelines.
I'm going to interrupt one more time because I have to. Okay, so mitigation. Some of us in a case, this wonderful mitigation specialist, Charlotte Holman, RIP, she spent 2,000 hours per case, minimum. In some states, Alabama, whatever, the Panhandle, the Belt states, I forget the name now. Sometimes the mitigation specialist gets 20 hours. Imagine 20 hours to investigate the life of your client. Samantha and I are very lucky that we work for attorneys that get us hours, but it is not easy to get hours to do our work. In federal cases, you most likely get them, but not in state cases, which is where it's needed the most. So just to give you just think about what it's like to get 50 hours for mitigation work, to present your client's life story that's going to prevent that person. The reason that we say he so much, believe it or not, in my years of practice, which is a lot, I won't tell you, perhaps I'm 68.
More than 30.
Oh, thank you, Sam. She's a mathematician. I've represented one woman. And you know what her crime was? She had battered spouse syndrome, and she killed her husband in his sleep. And thank God I got her 17 years, but that was many moons ago. God knows what would happen now.
Well, the question might derail. So I have this question, and I'm sure all of us have this question. Can you talk about two things? One, who pays you? And secondly, and most importantly, what do you do? What's a typical day in your mitigation life? What is it that you do?
Okay.
So this slide will answer that question.
Well, I'll tell you, so we don't have to read so much. The government pays us. Either the state of Florida pays us or the federal, we get a check from the U.S. Treasury Department. Our clients are all indigent. Even if you had money, none of us could afford a death penalty trial. I mean, OJ, which was many moons ago, they said it was $7 million. And that was not a death penalty trial. That was a regular trial. So it is, the cost is impossible because you have two attorneys, you have mental health experts, you have all sorts of experts because it's the battle of the experts sometimes. And so attorneys get these cases, either a public defender office, resource office, or a private attorney gets a case, and then they hire Samantha or me. And then we get paid by the courts. And what is a typical day for you, Samantha? And I'll say what's a typical day for me.
Okay, so as a mitigation specialist, we spend hundreds of thousands of hours investigating these cases. We're not just investigating the lives of our clients, it's a multi-generational investigation. At this point, the life of your parents matters, the life of your grandparents and their parents matters, because we know that trauma extends through generations, as does mental illness, as do intellectual disabilities. This isn't just a one-off. These investigations will take us around the world, and we are obligated to go. A majority of our job is to uncover records that may or may not exist by the time we get appointed to these cases. Records like school records, Social Security records, medical records that may or may not show traumatic brain injuries. We are the first person that comes into the team that is fully invested in the client's life story. I never ask my clients if they did or didn't do it because it just doesn't matter to me. Their story is what matters to me.
Samantha was just in an incredible case that I hope she has time to tell you about, where she got a life verdict. So we have gone to Honduras, Peru, Guatemala, Nicaragua, Puerto Rico, Santo Domingo, all over the place. We go into caves to look for water, toxicity in the water. We hire toxicologists that travel with us, videographers so that they can see where our clients are, the homes where they came from. We sit. I don't know if that's a chair because I don't have my glasses again, but we sit in places like that and make no judgment. Sometimes, like I learned very early on, not to wear cuff pants, because guess what I brought out with my cuffs? Well, little roaches. And that just happens. This is our clients' lives. I mean, they usually live in a lot of poverty.
So mitigation is not about bringing your client to you. It's about meeting them where they are. And where they are is the darkest place in their lives. It's about explaining to them that their normal is actually not so normal.
Yeah.
A lot of our clients, most of our clients, have a history of childhood trauma and abuse. They grew up in poverty. There's no billionaires sitting on death row. There's no billionaires facing capital punishment. A lot of our clients grew up just like us or worse. We all have mitigation stories. And just because one person might be, you come across a person that's like, well, I was sexually assaulted and I didn't go ahead and shoot up a school. Well, some people are more resilient than other people. Some people can push through the worst of their lives and some people break. And it's deeper than that. It's about seeing what your clients can't see and understanding what they refuse to understand. It's about walking them through bringing up their childhood trauma. It's about spending so much time with their families that they feel comfortable enough sharing their stories with you. This isn't just one interview with one person one time. You have to keep showing up for the clients and showing up for their families in order to get the information that's required in these cases.
Perfect. I want to say that little boy right there, he is this little boy in the middle.
That's Oscar.
Yes. He is doing life without parole at ADX. When people try to tell you that the jails are a walk in the park and that, they get 3 squares a day and they have a cot, and that jail, the ADX, is in Florence, Colorado, is underground. It's an underground jail where you never speak to another person. There's been studies about what solitary confinement does to you.
Right, you don't see the light of day, but 1 hour a day in where you are required to wear sunglasses because you're just kept in the dark 23 hours a day. This guy right here is, I don't want to say I have a favorite client because I spent so many years with my clients that they are really all my friends. But this is Steven Linares. At 17 years old, Stephen was arrested for a federal RICO conspiracy as part of MS-13. The government waited until he turned 18 to charge him with as an adult and impose the death penalty. At 8 years old, Stephen was recruited into MS-13 through no fault of his own. He fled to the United States to get away from the gang, and they followed him, and they found him here, and they recruited him again under threats of harming his family in El Salvador. Stephen's 22 years old. I met Stephen when he was 20. He's a wonderful, wonderful person. You can't tell from the pictures because he's not covered in tattoos like you would think, but Stephen is a musician. Stephen worked hard. Stephen wanted more for his life, but he also had to protect his family. And thanks to the mitigations conducted by me and the attorney, at his sentencing, which I was the only person to show up because his family was so terrified of walking into a federal courthouse and being detained by ICE.
Oh yeah, that's another thing.
I was there. The government wouldn't pay for me to be there, so I paid for myself to be there. Stephen will be released from federal custody February 9th of 2026 because Stephen was facing the death penalty.
Hey, Sammy.
And I will be there.
Sam, we have
Yeah.
question. Oh, questions.
I was wondering what role privacy plays in mitigation and like when you're presenting the case to the court, because it seems like you definitely get very personal with the clients, and so obviously there's kind of I imagine they give up some privacy in the proceedings of the case, and so how does that impact privacy with you as you're working, but also privacy when presenting their case to the court?
So confidentiality goes out the window because you have to tell their stories. And these are what Samantha was talking about. These are the most horrible things you have to say in front of the jury because that's who decides your fate. And even though the clients sometimes, they always tell us, don't trash my mom, please, but sometimes, and we try not to trash anyone because everyone is a victim. I mean, this is cyclical, but we have to, everything is public. Obviously, trials are open to the public and everything is public. Yes.
We are essentially re-traumatizing our clients and their families, which is why it is so important to spend so much time with them because we recognize what we're asking you to do, especially those parents and family members and friends that we ask to testify at these trials.
That's why you can't just drop them afterwards.
Yeah.
And that's why you can't have these big discussions with your clients about so many sad things and then leave. Like you spend hours in the jail. I think you...
First of all, thank you so much for doing this. It's been extremely interesting.
Oh my God, thank you for that.
I just have a question. It's related to just how involved you're with your client's life. This is obviously not a typical 9-to-5 job where you just clock out and that's it. Seems like you're really passionate about it. So I just wanted to ask if you have any time for yourself in the sense of how do you separate your personal life with just going to sleep at night and then not really thinking about work, if you call it work.
Samantha is 24/7 24/7 this work. But then again, she's 37 or 38 or something like that. The people ask me, what do you do? I go, I play tennis.
Yeah.
So that's my life. I have a boxer and tennis.
I'm in Miami. I just got back from Puerto Rico yesterday. I will be leaving tomorrow to St. Croix.
Yes.
This job is emotionally draining. Our mental health and our physical health matters. And so you need to learn to separate it before you burn out, before your body forces you to separate it. You are taking home the trauma of your clients.
You do. You can't help it.
But yeah, I work 7 days a week, all hours. You will get an email from me at 3 in the morning and then another one at 8 in the morning. It's just what it is. You have to be available to everybody at all times.
We do have an amazing group of colleagues that are doing the work. When you do death penalty work, there is a group of people and there's like resources and we go to conferences and there's always a glass of wine or two.
Well, I know we're running out of time, but I want to give time for one more questions. So we're going to take it from that.
Do the photo of Cuba.
Thank you
No,
for
they
your
want a
presentation.
They have a question.
So tell me about what does a mitigation specialist do? How do you prepare to do that? What's the educational requirements?
Oh, that's a good one.
There is no educational requirement by definition. You can come from any background. Social workers are
The majority,
a big part.
believe it or not, are social workers, lawyers that don't, like for me, I didn't want to be in front of a jury anymore. I didn't want to deal with state attorneys or federal attorneys anymore. So in 2008, I decided to just do mitigation.
Yes, journalists, people with a background in sociology.
Scientists, anything. You have to care about your work, and you have to be willing to put in the hours and to do the research, because getting records, imagine if your client is 40 years old, born in Honduras. I mean, you have to, and the reason that records are so important, records don't lie, because you present their brothers, their sisters, their aunts, their uncles. So what? They can, but records are records. They're like they a lot of credibility, and the experts need records.
Yeah, the records will tell you the stories that the clients won't.
Did that
the records
answer,
will
Shad?
fill in the blanks. Yeah, I have a background in criminal justice.
Do
I'm a
the
private
little-
investigator. I
Samantha,
have
get to the
I have a background in criminal justice. I have a background in psychology, and then I have a background in global affairs. I'm a gang specialist. I am certified in gang culture.
He's an overachiever.
Well, I want to ask everybody to welcome me in giving them a round of applause, please.
Thank you, but you're not leaving until you see this slide. Okay, this is an important slide.
The first picture is my mom.
This is an important slide. Okay, that's my sister. That's my sister. No, that's my niece.
That's my
her
mom.
That's her mom. That's her mom. That's me over there with the little bangs over there. And that's me at the end. The reason this is so important, this is in Cuba, is that when I got to the United States in 1966, Cubans were welcomed. We were helped. We were giving work papers. And I am convinced that it was what you were talking about. Most Cubans that came in that era were still brown people, but we were white compared to the Haitians and the darker people that came. And therefore, we were less discriminated. And my story is very different from a Salvadoran client that gets here, and they're looked down upon, and they're not helped, and anyway, all I'm telling you is that, that was done.
Yeah,
okay.
I'm sorry, I just needed to put this up for you guys because, I don't know if you're aware of this, but Florida's FIU's Death Penalty Clinic has a nonprofit project called the Balanced Justice Project, ran by Hannah Gorman. She's sitting here in the front. They are doing wonderful things for indigent defendants, and they are a great resource for our capital teams. They are indispensable, and if you guys want to find out more, you can scan her QR code. And we can talk about this for hours. I wish we had hours. But
Thank
I'm
you
sorry.
Thank you, everybody.
Come on, let's give them another round of applause, please. Thank you so much, Susy and Samantha. It was such a pleasure to have you both here and to really learn and also create awareness on this topic, and also kind of learn as well all the amazing work that you do as well for people around the world, advocating for them.
Thank you.
So thank you so much
Thank
for
you.
this
Thank you,
moment, and also we hope to have you back.
I want to come back.
Definitely a part 2.
What are you doing Friday?
All right, so as a reminder, TTR continues again next week. We're now moving online, so just join us via Zoom. We're going to be having a conversation with the organization Results on the Global Fund. Thank you so much for coming, everyone.
Thank you, guys.